Oh, Good morning, everyone. I'm going to try to keep this session fairly light. I know that most of you have been bombarded by a fair bit of information around the GDPR, and I want to keep this session more on the practical side and less on the theoretical side. We'll kick off by looking at the purpose, and this is something that I tell to every single one of our clients when we engage with them. We tell them not to focus on compliance. If you try to approach this like a checkbox exercise, similar to PCI DSS or ISO 27000, it's going to end up being quite expensive, quite painful, and most importantly, pointless. The GDPR was never really developed with a compliance approach in mind. It was developed as a transformation, as a new way that organizations will handle and manage information belonging to their customers, clients, and partners. Over the course of today's agenda, we'll cover the origins of the GDPR because I believe it's very important to understand where this regulation came from, because without that, you won't have any point of reference as to why we're doing this today. We'll look at distilling down the regulation just to understand what it's all about. We'll look at the value of information and the value of risk. And then we'll look at what BlackBerry is doing for the GDPR and how we can start to help you. The GDPR is really a shift in terms of what regulation requires you to take care of personally identifiable information. It's being described as the largest shift in terms of privacy regulation, but this is not entirely true. It's not true because of the history that precedes it. Back in the late 1970s, around 1978, the OECD, the Organization for Economic Cooperation and Development in Europe, came up with guidelines for the protection of privacy. And this formed 8 basic principles that are at the basis of most privacy regulation today. It was non-binding, it was purely there for those who were interested in better preserving information of a private nature. Fast forward to 1995, and you have the first directive coming from the EU, and this was EC 9546. It had to be adopted in each and every member state into their law, so it has to be adapted, it has to be interpreted, which is why each and every member state ended up with a slightly different version. In the United Kingdom, we ended up with the Data Protection Act of 1998, so it took 3 years to absorb into UK law. But it was, when you think about it, this was developed in the early 90s, prior to social networking, prior to the boom, the information boom. So it became, it was unfit for purpose very, very fast. If you fast forward to 2012, early conversations around the need for a new directive or a new regulation came about, and that were the early conversations that we were involved in concerning the GDPR. So back in 2012, we started engaging with the European Commission around what was broken with EC 9546, what was broken with the Protection Act, and how this could be fixed. So the GDPR has been in the works for a fair bit of time, and the principles upon which the GDPR is based have been around since the late 70s. The GDPR is a very mature piece of legislation, and the reason why most of us like it is because it's no longer a different regulation in every single country. It's one common set of laws. You don't have to have different rules for different entities. It allows you to effectively understand one set of laws and then apply them across your organization without having to cater for differences across each and every member state. So it was built with 2 things in mind. First of all, transparency, and secondly, it was built to address the weaknesses that came with the previous directive, or the Data Protection Act for that matter. But at its core, the GDPR is quite simply requires organizations to be responsible for the data they hold on individuals, commonly referred to as personally identifiable information. There's 200 or so pages within the GDPR, and they are basically guidelines as to how the European Data Protection Board, previously known as the Article 29 Working Party, believes businesses should go about achieving this now. So at its core, it's just a regulation telling organizations how to manage personal identifiable information. And in an ideal world, this would not be needed because ultimately it's how you want your information handled on behalf of companies that serve you. Having said that, most organizations differ in how they believe this should be done, so we end up with a regulation. And I'm a big fan of deregularization, but in this particular case, we've seen so many abuses of personal identifiable information that the only thing that will address the gap that exists today is a solid regulation across all of Europe. So, personal identifiable information is really the crux of this. What is personal identifiable information? The definition has not changed since the 1998 Data Protection Act. So it's any information relating to an identified or identifiable natural person. And the first part of this definition, not so difficult. The second part is the part that a lot of us have debated over the past 10 years, identifiable natural person. So back in 2002, there was a huge debate as to whether or not IP addresses were considered personal identifiable information. And the answer that came out was yes, they definitely are. So an IP address on its own is considered personal identifiable information because given a few more bits of information, you can trace it back to an individual person. But does the GDPR apply to you? A lot of organizations ask that question. They say, well, we don't really handle much personally identifiable information. We don't hold much information on our clients or our customers. We just have a few thousand employees and that's it. The GDPR applies to any EU-based organization as well as any company that processes data of EU citizens, regardless of its physical presence in the EU. It not only applies to what is referred to as data controller, but also data processors, and I'll explain that. Let's say you work for a bank, and that bank collects information on their clients. That bank is, in this scenario, a data controller. They're the party that makes decisions as to how information is collected and used. But if the bank then wants to get a third party, let's say marketing firm, to conduct a few campaigns on their behalf, and they hand them a bunch of personal information belonging to their clients to reach out to them, in that scenario, the marketing firm is a data processor. Previously, the data processor was not held liable for breaches. Under the Data Protection Act, the processor was liable to the controller based on whatever agreement they reached out between each other. But under the GDPR, every single processor and sub-processor is also liable to the authority. And this is a massive change because whereas previously controllers were fairly geographically located in the EU, it was fairly simple. Now, this regulation applies not only to the controllers, but to every single one of their providers, regardless of where they are in the world or where they host their services. So if you, as a processor, take on the responsibility of handling, of processing information pertaining to EU citizens, you automatically come under regulation. There is no exception or derogation that you can put in your contract with the controller that will absolve you of the responsibility. You're responsible not to the controller, but to the regulatory authority. And this is a huge difference because what this does is it takes the GDPR and transforms it from European legislation to an international privacy legislation. The value and risk that information carries has never really been discussed in great detail. So if you look at this graphic, I just want to give you an idea of information and the risk and value that it carries. If you're looking at your organization, the first step that we normally work with our clients is to develop a data assets register. This is very similar to the assets registers that you maintain for your desktops, your laptops, your printers, your servers, but it's focused on information and the information assets that you hold. And this is important because we maintain detailed asset registers of laptops, desktops, smartphones, and tablets, things that depreciate in value quite fast. But we don't maintain assets registers for the information that comprises the larger part of the value of any of our organizations today. Most of us trade in information or depend on it largely to generate revenue. So if you look at this graphic, on the left-hand side, you have client information. The green dollar signs refer to value, the red dollar signs refer to risk. Client information carries a lot of value, a small proportional amount of risk if protected properly. So this is something that organizations value quite greatly. On the right-hand side, you see log data. Plenty of personally identifiable information has absolutely no value to the organizations and only carries risk. And all the way in the back there, you see HR insurance records. They provide absolutely no value to the organization. You are under no requirement to hold them, but they represent quite a bit of risk. And we've gotten used to holding all sorts of information because, and I hate this quote, storage is cheap. Storage isn't cheap if you factor in the risk that information carries should that information be breached. So if you think about it, all this information now that you're holding to because storage is cheap is actually quite expensive if you factor in the fines and the damage that you'll suffer following a breach. So it's important to understand the value of information. This is a substantial transformation in of itself. Why? Because previously in IT, we've kind of been pigeonholed as the purveyors of the servers and the printers and the desktops and laptops, whereas we really need to transition into the purveyors of information to zeros and ones. The silicon and the plastic is worth nothing compared to the information within it. And a lot of CIOs are realizing this right now, are noticing that the central letter in their acronym is information. And the focus on information is critical because it is where most organizations either value lies today or where their value is moving into the future. We conducted these value and risk information assessments for some of our clients, and with some of the banks that we work with, we found out that they spend 14 times more securing information, securing dollars and cents in their vaults than they spend securing information sitting in their data centers. And this is a problem for the GDPR and for organizations generally speaking. So let's look at some examples. What are your rights under the GDPR, you as individuals? Well, you have the right to access your information. This is, if you've ever dealt with subject access request, that's quite important. You have the right to rectify the information held on you by third parties. You have the right to data portability. That means you can show up as a third party and say, I'm moving to a competitor. Could you please give me my records in an electronic and readable format? And you have to provide this in an acceptable amount of time. There's the right to erasure or the right to be forgotten. There's the right to restrict processing. There's the right to object to automated processing. So as an individual, you have a fair few rights under the GDPR. But if you look at this, it's all situated around one particular feature that you must maintain. And this is the awareness of where a piece of information belonging to individual is at all times, whether within your network or beyond it. So, as an organization, if I'm your customer, you must be aware of where my information sits at any and all time, whether it's within your data center, whether it's in structured databases or unstructured files, or whether it's with a third party conducting some processing activity on your behalf, be it business intelligence, marketing, or PR. So it's important to look beyond each and every different subject access right and understand what is the regulation asking you to do. And that's the practical side of the GDPR. Understanding what is the regulation actually asking me to do, and then you'll find that all of these that fulfilling these subject access rights for your clients or your employees becomes quite simple. Because if you look at each one of these in its own right and think, I have to create functionality to access, I have to create functionality to rectify, I have to create functionality to be able to export information on an individual, I have to create functionality to be able to delete information on an individual, you'll find that it's quite cumbersome. But if you look beyond it, and this is what the difference is between a partner that understands the GDPR and a partner that's just read the regulation, same as you, is understanding what exactly was the Article 29 Working Party, which is effectively a grouping of all the data protection authorities, asking you to achieve. So let's just jump straight into the next steps. Now you're starting to understand the GDPR. The first step is to really grab a piece of paper, and if you haven't done this already, you want to start it today, because the GDPR is still coming around in May, but it will come around very, very fast. And it's very important to note that there's no such thing as 100% compliance. You are building toward a better understanding of your information. That's what you're aiming at. That's what the regulation really wants you to understand. It wants you to gain a better understanding of the information that you hold. It wants you to reduce the information that you hold substantially to just the information that you need, and that's called data minimization. It's the first step of any kind of GDPR undertaking. You want to understand how the information exits and enters your organization, so how you share information both internally and externally, and how you collect information from clients. So it wants you to create an understanding of how information flows through your organization. What is the information lifecycle? And then it wants you to track information as it travels through your organization. That's quite important, because then if you understand, if you have limited the information down to exactly what you need, and you understand how it exits and enters your organization, you can then demonstrate compliance. You can point at the processes how information flows through your organization. You can demonstrate that you're only holding on to the bare minimum, and that you have the right to hold on to the information for one of the many reasons that are allowed under the GDPR. With us here at BlackBerry, so I'll give you an example. And yes, it's an example of one of our products, but this is an enterprise file sync and share solution called BlackBerry Workspaces. A lot of our customers have difficulty with unstructured data, files that they share with third parties. And what happens if one of the clients comes in and says, okay, I want you to delete my records. Then you have to be able to reach out to that third party. You have two options. You can either maintain a tracking record of everything, which is extremely difficult, reach out to the third party and under your SLA with them, ask them to delete records on that individual. Or you can have a solution like this. This solution allows you to map every single document that you've shared externally, because everything is shared through the system, whether it's coming from one of your flat file shares, from an Office 365 repository, from SharePoint, it doesn't matter. Everything goes through the system, so everything is searchable. So let's say, for example, a client comes to you and says, I want to delete all my records. You can go onto the Workspaces search screen, search for that client, for the client's name or a client ID. It automatically flags every single file in your system that's been shared externally or internally, and it allows you to update those files or restrict access to them by both internally and externally. This is quite important because this allows you effectively to gain control over your unstructured data. And it's an example of what the GDPR is expecting of you. The GDPR expects you to have control, to have awareness. And without some change in your subsystems, this will become very difficult. You have two options, really. You can either change the way that you work or change the systems that allow you to achieve what you need to achieve. But at the end of the day, and I cannot stress this anymore, the GDPR is not a product. Anyone who shows up at your front door and says, here's a solution for your GDPR compliance, either does not understand the GDPR or is grossly misrepresenting what they're offering. The GDPR is a transformation of how information is acquired, valued, stored, processed, and ultimately retired. It involves policies and processes. It involves technology, and it involves people within your organization understanding how they fit in this larger thing. So it is a transformation. When we approach new organizations for GDPR work, or ones that have been working on the GDPR compliance for the last 2 or 3 years, we found that they look at one segment but not the other. They think technology is the end-all and be-all, or policies are going to solve everything, or just a lot of training is going to solve everything. It's not. Because it's a transformation, you have to approach it as transformation. You can't approach it as just a new set of policies, a bit of training. You can't. It's not going to work. And I mean, I say this with all the love in the world. It's going to be very, very difficult if you approach it that way. And we've seen large organizations with an insane amount of resources dedicated towards this fail miserably because they've approached it like a checkbox exercise, thinking that a bit of technology, a bit of training, and we're good to go. So, where do you start? Understanding where you stand is really where it's important. So, an assessment, whether you do it internally or you get a third party to do it for you. We've done a fair few of these. It's important to understand where you stand and not just do some small summary assessment. No, look at your information, gain a better understanding, but don't do it just for the GDPR. Do it for a bigger purpose. Gain a better understanding of the information that you hold and the value of that information. It's going to change your organization. Compliance with the GDPR will come as a side, as a fringe benefit. But the gain that you're really going to achieve is a better understanding of the information that you hold and being able to really leverage that information to generate value. And do not underestimate the importance of people. I'm going to harp on this quite a bit here. When you either are resourcing for your privacy team, be it externally from a third party or internally in terms of upskilling, make sure that the people you are working with are properly geared to address this task. Understanding the GDPR is a lot more than just getting a lawyer who's read the regulation. Understanding the GDPR is a lot more than somebody who's read the regulation and understands IT. It is a lot more than that. You need people who have the right certifications, have the right credentials, but also have spent the time understanding why this regulation is coming about, have worked with data protection authorities either in your region or beyond them, to understand how they're going to apply this regulation and how they view compliance or non-compliance. You want to be able to better understand how information is going through your organization through these people. So when you're resourcing for your privacy team, either internally or externally, make sure that you've got the right people. There's a lot of snake oil salesmen out there, and there's a lot of people offering GDPR services that frankly aren't fit for purpose and that are really just adapted from other compliance exercises they've done in the past, thinking this is no different than an ISO 27000 or PCI assessment. Don't approach it that way. The GDPR is a complete transformation, and the people that work with you on this transformation need to have an in-depth understanding of what is required by the regulation and what is required by you as either a data processor or a data controller. It's a huge advantage gaining a better understanding of where your information sits and what you can do with it. It's a substantial benefit, and from a competitor perspective, becoming GDPR ready faster places you at a huge advantage when you're providing services to third parties who are looking for GDPR ready providers. This is the crux of the matter. Most of us do business with third parties, and those third parties will be looking at you for GDPR readiness when you provide them with services involved in processing information. I hope this helped. Shirley. I'm not sure if any questions came in. I'm happy to answer them.
Yep, thank you.
Thank you.
Remember, you can submit your questions now. We've got a few questions coming through. So one is about data processors. How would you recommend businesses review their relationships with data processors, or how can they ensure that their data processors are compliant with GDPR?
So your relationship with data processors needs to be a lot deeper right now. So previously, you may have had an SLA or an agreement with a data processor. You'll have to review them. So expect between now and May 2018, if you're processing information on behalf of a third party, expect all your agreements to see either verbatim or adapted GDPR requirements. So that's number one. Number two, because of the size of the fines, both the processors and the controllers are going to be looking at a lot more detail. The controllers will be looking at really understanding how the processors are handling information. They will be looking at if there are any third parties to those processors that are handling information, are they compliant as well? That there's no limit as to how deep the chain where a breach can occur. It can really occur anywhere down the chain. So if it's the 10th processor is down the line, then everyone between that sub-processor and the client is liable because everyone was aware. So you have to then take on more responsibility. As a controller, you need to look at your contract to make sure that they properly represent what the requirements of the GDPR represent. And then you have to make sure, hands-on, make sure that the third parties are properly compliant and are taking good care of the information. This may involve audits. This may involve some form of certification that the third party has to achieve. The GDPR does hint at ISO 27000 as a good standard of information management. But ultimately today, there's no such thing as a GDPR compliance or certification, formal certification as identified by the EU. The GDPR within it maintains that you can have those kind of certifications in place, but as of right now, there is no certification body as of yet.
Okay, great. Thank you, Nader. We have another question around the right to be forgotten. How should the right to be forgotten and the business requirement to maintain, financial and compliance records be balanced?
Well, the right to be forgotten isn't absolute. So let's say, for example, you maintain financial records from credit card transactions, and an individual whose transactions those are comes and invokes the right to be forgotten. You will have to delete all his records, but not when it contradicts another regulation. So, for example, PCI DSS requiring you to store financial records for a certain amount of time, that still applies, and you are required to maintain his records. So, if you look at delegations, or it's the fancy term for exceptions that the GDPR identifies for all of these rights, for all of subject access rights, they say that you can continue to process information on behalf of an individual if you have and it gives you a whole bunch of exceptions. So, for example, for legal purposes or to fulfill a contract, all of these give you the right to continue holding on to this information, even if an individual has invoked the right to be forgotten. What they don't want you to do is to reach out to the individual. So think of it this way. Let's say I invoke the right to be forgotten, and I've previously purchased things off of your site in the past year. You delete my information from your records, you delete everything except all the transactions, obviously, for logging purposes, for bookkeeping purposes, you have to keep those. What I don't expect as an individual acting invoking this right is to get an email from one of your marketing people or one of your salespeople saying, you previously purchased something from us, would you like to review that purchase, or let me tell you about a new product. I don't expect to see that. And if that happens, then you're in breach of subject access rights, because I've withdrawn my records from your environment, and I don't expect to get somebody to reach out to me. I do expect to be contacted though if you have a breach that involves my financial records that you had to hold on to. So you see what I'm saying here. It's not, the right to be forgotten isn't absolute. It is intended to be balanced with the other requirements that you have in place. Yes, there's some complexity there, but honestly, we've done this with a lot of clients before, and even though it is complex, it's not impossible, and it's not that difficult once you get a hang of it.
Yeah, great. Thank you, Nader. So another question is around the transformation. So you mentioned during your webinar that GDPR is about transformation. And so if this is the case, who should be involved in forming a working group for GDPR, or to talk about GDPR strategy?
In terms of who should be involved, it will start from IT. I've seen it start from legal, and I've seen it start from IT. I think it's better if it starts from IT because there's a better grasp of where information sits and how it's being handled, but it could start from either location. You need to have senior leadership support because it is a big transformation. It is going to require resources. It is going to require people and focus. The first step is normally communication. If you're going to take on this task, or if somebody's giving you responsibility for the GDPR, then the first thing is to educate leadership on what this is going to mean to the organization and why we're doing this, and what kind of exposure exists if we don't go down this path. The working group, once it starts to form, is going to be multidisciplinary. You want to have people from the organization who own the information. So the data asset owners, those normally are the business units, because they're going to have to make changes possibly into how they work or into their policies and procedures that involve compliance with the GDPR. So it starts by education of leadership to make sure that you have the right kind of support, and then from there, what we do normally when we're engaging a new client is to identify the large centers of data processing. So where you have lots of data movement, either writing records, reading records, that's where you want to start, because that's where most of your data is being processed, and that's where you have most of the value. And then we work down from there. So we use a combination of interviews and log data to help us identify where is the busiest part of your data-driven organization, and then work our way down that list.
Yeah, great, thank you. We've got time for one more question. So this is still talking about who's responsible around, managing the GDPR compliance. Do businesses need to have a data protection officer? And if so, who should take the role of this?
Okay, so most organizations will require a data protection officer. If you are in the business of handling large amounts of personally identifiable information, then you're going to need a data protection officer. If you do not handle large amounts or a substantial bit of personally identifiable information, you may get away with having someone within your organization share the responsibility for it. Where that role should sit, there's three options. There's a debate whether it should be an IT person or a legal person. Lawyers obviously want the responsibility because, well, lawyers want the responsibility. IT also want the responsibility because they view it as information as part of their role. But ultimately, it needs to be someone either within IT or within legal that has a good grasp of your data life cycle. A third option is an external third party providing outsourced BPO services. And with a third party, they're fairly limited in what they can do because they're not aware of the ins and outs of your organization, but they can provide you with sufficient guidance, which is exactly what a DPO should do. A DPO should not be hands-on. A DPO should be providing guidance to the organization, effectively policing how the organization handles personally identifiable information. That's the role of a DPO. So when you're assigning this role to someone, you have to think who's best to police my organization internally.